The defendant, Aaron York Dean, has been found guilty by you of the offense of manslaughter. Therefore, it now becomes your duty to determine the punishment to be assessed against the defendant. The punishment for the offense of manslaughter is by confinement in the Texas Department of Criminal Justice for any term of not more than 20 years or less than 2 years. In addition, a fine not to exceed $10,000 may be imposed. You are instructed that in determining the defendant's punishment, you may take into consideration all of the facts shown by the evidence admitted before you in the full trial of this case and the law as submitted to you in this charge. In this case, the defendant has filed before trial his sworn motion in which he requests that if he is convicted, he be placed on community supervision. If you find that the defendant has not ever been convicted of a felony in this or any other state, and you assess the punishment of the defendant at confinement for a term of not more than 10 years, and you recommend that he be placed on community supervision, then let your verdict show the punishment which you assess, and further show that you recommend that his sentence be suspended and that he be placed on community supervision. If you recommend that the defendant be placed on community supervision, the judge shall determine the conditions of community supervision and may, at any time during the period of community supervision, alter or modify the conditions. The judge may impose any reasonable condition that is designed to protect or restore the community, protect or restore the victim, or punish, rehabilitate, or reform the defendant. You may not recommend that part of the period of confinement be served by incarceration and part by community supervision. Should the punishment assessed by you include a fine, a recommendation of community supervision should state whether or not the fine will be paid or be suspended and probated. Whether you do or do not recommend community supervision for the defendant is a matter that rests within the sound discretion of the jury. However, if you do recommend community supervision, the court is required by law to follow the jury's recommendations. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a privilege accorded to the defendant, and in the event he does not testify, that fact cannot be taken as a circumstance against him. In this portion of the case, the defendant has not testified, and you are instructed that you cannot and must not refer or allude to this fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Your verdict must be by a unanimous vote of all members of the jury. In deliberating on this case, you shall consider this charge as a whole, and you must not refer or discuss any matters not in evidence before you. If you need to communicate with me during your deliberations, the presiding juror should write the message, ring the jury call button on the wall, and give it to the bailiff. I will either reply in writing or bring you back into the court to answer your message. You are the exclusive judges of the facts proved of the credibility of the witnesses and the weight to be given to the testimony, but you're bound to receive the law from the court which is herein given and be governed thereby. And I've signed these instructions as judge. The last 2 pages of the instruction contain the respective verdict forms. The first verdict form says community supervision not recommended. We, the jury, having found the defendant, Aaron York Dean, guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment and confinement in the Texas Department of Criminal Justice for, and there is a blank, for the presiding jurors to fill in the number of years that the jury agrees to. In addition, we do or we do not, and the presiding juror will circle that phrase, assess a fine in the amount of blank. So if you assess a fine, circle we do assess a fine. If you don't assess a fine, circle that. We do not recommend community supervision. And there's a space for the presiding juror to sign on that form. The second verdict form is on the last page, and it recommends community supervision. So in that situation, the presiding juror will fill in the number of years that you assess, between 2 and 10. Again, you can assess a fine or don't have to assess a fine. If you do assess a fine and you're recommending community supervision, there's a third blank for the presiding juror to certify whether you want the fine that you assess be paid or that it be suspended and placed on probation. Ms. Diener. I need the lights, Brian.
Is the court.
Yes, ma'am.
Tatiana's family, they received their license on October the 12th. They received their license without her. They'll never get her back. As we approach the Christmas holiday and the end of this year, we think about those that we love. We grieve for those that we've lost. And for them, that's sadness. To grieve. There's multiple stages when we go through the losses in history. For those of us that have gone through that and know what that's like. A few years can pass, and yet it feels like just yesterday. You heard Darius testify. You heard Ashley testify. For Ashley, for Amber, for Darius, for Zion, their whole lifetime will be without her. There's a part of grief that we all suffer when we get to a certain point, when we think about that person. There's a realization for us all. It's the finality of it. Right? In your heart, we miss them, we love them, and then we really realize they're never coming back. And that's the hardest part. And that's worth something. And in this case, it is worth something. Her life is worth so much more than probation sentence. So much more. This family, her memory, her legacy, this community deserves more. And punishment, we brought you multiple witnesses. Those were witnesses we were not able to bring you as witnesses. You heard from Dr. Kyle Clayton, a forensic psychologist. This is an expert that both sides have. He testifies, works for defense, testifies, works for state. Whoever calls him, he does good work, and he testifies to whatever he finds. He was hired by the Fort Worth Police Department, as he's been in many other agencies, to do a pre-employment psychological evaluation. Narcissistic, grandiosity, and grandiose tendencies, domineering, over-controlling, forceful, dominant personality traits, uncritical of himself, denies flaws, minimizes behavior, little tolerance for disagreement. To be aggressive, has an unrealistic view of himself. Someone that thinks that he can fly all of us in a commercial airline despite never having an hour in training. Someone that when you're asked to rank yourself, 9 out of 10. Not suitable for a position. Psychologically speaking, he is not suitable because these tendencies that are well-formed, ingrained, a thread throughout his entire personality, these are unchanged traits that put himself and others at risk. It is like a roadmap back in 2017 to how we ended up here and how we lost Tatiana back in October of 2019. These things don't change. And how do you know that even in the 3 years between the time that was done and today? Because last week, the defendant testified, I think did a pretty good job out there. You shot a man in your own home. You disregarded every single standard operating procedural, general order, and just pure, reasonable human instinct. And a 28-year-old woman died, and you did yourself a fine job. You did yourself a deed. It's not somebody that thinks you've done anything wrong. When the defense counsel gets up here, they're going to talk about the witnesses that they call. And those witnesses are not witnesses that you can hear from until now, until punishment. You heard from us, Dr. Clayton. You heard from us, Darius Carr. You heard from us, Liz Turner. And why is Liz Turner important? Because we wanted to show everything that we knew about him. And it's important to know, going all the way back to college, that's the way that he treats you. He's entitled, he's arrogant, he's aggressive. That was 20 years ago, and she was talking to you from a place going right back there. She remembers that. She got emotional. It's hard for her. Because that's who he is.
Give you 7 minutes, Ms. Deacon.
So when he gets up here, when the defense counsel gets up here and talks to you about why you should give him probation, because that's what they're going to do. They're going to get up here in a minute and they're going to ask you for a very low sentence of probation. They're going to ask you for mercy. Mercy's been shown already for this defendant because there's no mercy is earned. It is not received. And I want you to listen to why they're asking you for a low sentence of probation. Because his family got up here and said he could be found. Every case that I prosecute, there's a family member that gets up there and says he could be found. It's hard to do. But you know, I think it's important to think about the witnesses that we didn't hear from. This is much the ones we did, right? Family members. We heard from one field training officer, just one single Fort Worth officer that said, I knew him for about 3 or 4 weeks, didn't have very good personal skills, he kept up, I don't know anything about his case. But don't you know that the Fort Worth Police Department and all those guys and girls that work for him, 18 months side by side with him, almost 2 years. Don't you know if they had something good to say, they would have been in here? There would have been a line out the door. Don't you know that those 3 psychologists that gave him a passing score, if they had something good to say, if they disagreed with Kyle Clayton, don't you know they've been in here saying that? They would. Guarantee you they would. But instead, we have a family, which they're good people. This is not their fault. This is not their fault. But valuing them or him over her is a tragedy. It is not right. It is not just. In this case, the only appropriate verdict is the maximum sentence. It's the only thing in the case. And when the judge talks to you about the fourth charge, I want y'all to think about, and y'all don't have copies with you, you'll be able to go back and read this. When you go to this certain page, I want to ask you, do you feel comfortable with the fact that the judge gets to set the terms of probation? He gets to get off. If he wants to get off early, judge sets the terms. You heard from the probation officer talk about probation and how it is no different than what all of us do every day. That is not enough. That's not even a slap on the wrist. You heard that this defendant has been out on bond for the last 3 years with his family, laughing, doing projects with them, something that they don't get to ever do. They don't get to ever do that. Doing probation values that over them, and that is not okay. The other thing that's talked about in the fourth charge is a fine. I can always get questions about the fine. If you want to put an exclamation point on your verdict, then you put a fine. It doesn't go directly to you. It goes to a fine. So you put a fine as an exclamation point. When you think about this case, you all here today, they go home without Zion never gets to have this case. It doesn't matter if it's a year from now, 5 years from now. People are going to ask Zion, what happened to Aunt Kay? What happened? What did the jury do? And thankfully now with your verdict, you get to say that they found him guilty. They're also going to ask another extremely important question. What did they do? What do you want Zion's answer to be? The only just verdict is 20 years. Anything less is a travesty.
Mr. Gill?